It just covers all places. Oh, I don't know as many yet.
For those of you who are just joining us today, I'm Dr. Randall Sechrest, the medical director of the Montana Spine and Pain Center here at St. Pat's. And I was asked to host this meeting today by the American Cancer Society. And it's a joint venture amongst several different organizations, including the American Cancer Society and several of the other organizations that are interested in pain management in Montana. So anyway, today what we're going to focus on this morning are the legal aspects of pain management, the issues surrounding medications, surrounding interventions that we do, those sorts of things. So I think we've got a very good lineup for you this morning. I wanted to recap what yesterday brought us. In the morning, we really started out with Dr. Rudin providing us with two key things. One was the science behind pain and the science that we're beginning to uncover in terms of not only the etiology of some of these painful syndromes, but just the physiology and the pharmacology of pain in general. Second, I think we tried to create a vision for, okay, if we're going to deal with this patient population and try to improve our handling of chronic pain, where are we going? What would an ideal situation look like if we were to build something for Montana that really comprehensively addressed the chronic pain issues? So looking to the future and really trying to identify where we want to go. And I think, again, Dr. Rudin did a great job of giving us not necessarily, the castle in the air, but the tools and sort of the way we're going to get there and try to determine what it's going to look like in the end. In the afternoon, what we tried to do was really give you a crash course in some of the best practices we have right now. And for those of you who are either new to pain management or are struggling out in the rural areas with how do I do this, how do I serve my patients well and yet not increase complications, not create problems, what we tried to do is at least give you some of the basics that are out there now. And then yesterday evening we had a very rousing discussion, for those of you who are here, on a panel for the barriers and effective access to chronic pain management. And it was an interesting panel for lots of reasons. And those of you who are here, please share with the ones that weren't. This morning, as I said, we're going to begin to tackle some of the more thorny issues, and that is trying to get a good feel for what the issues are, not only from the chronic pain side, but also from the negative side of chronic pain management. And that is the problems that some of the treatments, such as the narcotics, the opiates that we use, have. I mean, that's a complication that we have to address, we have to do better, and we have to really begin a dialogue that allows us to understand the true risk and learn ways to mitigate that risk as best possible. So my first speaker this morning is going to be Dr. Scott Fishman. Dr. Fishman, as you will recall from yesterday's discussion, is the author of the new book. What is it? Responsible Prescribing of Responsible Opioid Prescribing, which Mike McGrath told you would be coming to every prescriber in Montana this fall. So that's going to be a huge benefit, I think, to everyone. Dr. Fishman is the chief of pain medicine and a professor of anesthesiology and pain medicine at University of California, Davis. He's the author of that book, and today he is going to talk on those topics.
It's really a pleasure to be here and an honor to be associated with this program. I hope you all are doing wonderful work here in Montana, and you're to be congratulated. Thank you, Dr. Seacrest. I wanted to mention that you guys seem to have a pretty good supply of pain medicine docs here in Missoula, which seems like a wonderful small town to me, from my perspective. But I want to tell you, you have a new pain doc in town, Dr. Dave Junker, who just came from our pain program in California. He trained with us last year. Before that, he was providing care in Iraq for our military, and he's a wonderful physician. I think he spoke to you all yesterday. I just wanted to tell you that. It sounds like you guys have very, very good pain services. I also want to make a disclosure that I'm speaking on a topic that some might say I'm in fact not qualified to speak on. I'm not a lawyer. I don't offer legal advice. The information presented here is from the perspective of a concerned physician or clinician, a perspective I think probably many of you in this room share. And I collaborate with every company that's willing to offer unrestricted support for education, and that's how I keep myself clean. I make sure that the work that I do is unrestricted, and I don't work with any sole company. I thought I would tell you a story that some of you have probably heard me tell before. It's the story of a physician who dies and goes to hell. Has anybody heard this before? Yeah? All right. So for you, it's not a true story, but for everyone else, it's a true story. And the physician gets to hell and is very upset that he's in hell. The devil's there, and the devil says, all the physicians are upset because they like choice. They don't want anyone to tell them what to do. So the devil says, I'll let you make a choice. You can spend eternity in room A or room B. So the physician goes and sees room A. It's an ICU with patients stacked to the ceiling and beepers and blinkers and body fluids and not a nurse to be found. Peeks into room B, and it's a room full of hospital charts, and it's an eternity of medical records. And he notices out of the corner of his eye room C, and in room C are 3 or 4 well-groomed doctors being followed by 3 or 4 nurses, rubbing their shoulders, bringing them coffee, saying things that I rarely hear, like, can I get you something? And he runs immediately to the devil and he says, I've made up my mind, I want to spend eternity in room C. And the devil laughs and says, oh, I'm sorry, that's nurse's hell. So, I tell you that story because when I tell my colleagues that I'm a pain specialist, they often offer me their condolences. And, I wonder about that because I can't think of a better place to be as a clinician. I went into this business to help people who are suffering, and that's what I get to do every day. But it's very easy to feel damned if you do and damned if you don't. And all you have to do is look at a couple of key issues to drive that point home. But we have 2 public health crises in America right now that are colliding. You've heard about them, I think, over the course of this program, and that is undertreated pain and prescription drug abuse. And they're both problems. And they both deserve action, and the solutions to one don't have to undermine the other. Okay, I want to say that one more time. The solutions to one don't have to undermine the other. There's no reason why treating pain should make the world less safe for people who have pain, and treating pain should make the world less safe for society in general. But if you do look at the statistics on prescription drug abuse, they're quite chilling. And I can't overemphasize the problem And we definitely need solutions, and solutions are out there. The Senate actually probably put out the best data that we have. They put this out in January, designating the week of February 10th through the 16th this past February, as National Drug Prevention and Education Week. And they said 25% of youth in the 10th grade reported use of marijuana during the past year, and the overall rate of current illegal drug use amongst persons 12 or greater is 8.3%. Interestingly, that's been stable since 2002. Nearly 6% of 12th graders have used over-the-counter cough and cold medications in the past year for getting high. And I think what you see here is a trend of seeing increases, not overall, but in our youngest citizens. Vicodin remains the most commonly abused drug amongst 12th graders. You know, it's interesting, I moved to California from Boston about 10 years ago. I ran the pain program at Mass General Hospital, and we never prescribed Vicodin. When I moved to California, I had to look it up. Now, I understand you guys, in this state, it widely uses Lortab, which is very similar. I had to look up Vicodin, and that surprised a lot of people, but we didn't use it. We used a lot of Percocet, so there's a lot of cultural variation in the drugs that are used. But there are other forces at hand, and there are real clear forces in California as to why California docs used Vicodin. And it had to do with the triplicate prescription monitoring program we have there, and I'll talk about that more in a little bit. The Senate ultimately said the total economic cost of drugs, alcohol, tobacco abuse in the United States is more than $500 billion a year. And what they've been focusing now on, and I think that the folks from law enforcement, and particularly the DEA, will echo this, is that the problem goes beyond normal borders. Put yourself in their shoes. You've got now a shift from illicit non-prescription street drugs like heroin to prescription drugs like OxyContin. Many feel that this is just a shift. The population hasn't changed. They've just gotten smart, and they've recognized that pharmaceuticals make these drugs better than people can make in their garages or in their third world countries. And the distribution is actually pretty easy. And consider the whole internet pharmacy problem. This is what Joseph Califano, the former Secretary of Health and Human Services, had to say, that anyone of any age can obtain dangerous and addictive prescription drugs with the click of a mouse. They looked at from Columbia, they did a search, and they found 365 internet pharmacies. And the majority of them would provide you with controlled substances, most without a prescription. So in their study, they essentially used standard internet browsers and searched on standard terms, came up with 159 sites that directly sold controlled substances. The others were simply duplicates. There was a total of 365, but really there was a core of 159 because all the others related to those, they streamed into those 159, and of those, 135 or 85% did not require a prescription for a controlled substance. The DEA said that sites can literally open up for a week, close, and open up under a different name, which gives you a sense of the problem that the feds are having now in dealing with essentially these open borders of drug trafficking. The DEA, the Office of the National Drug Control Policies, and others are working on this, and they're looking at, most strategically, working with credit card companies now. And targeting these sites and targeting these purchases actually through the means of paying for the drugs. And there are a couple of national laws out there. The Ryan Haidt bill requires certification of online pharmacies, which is probably going to pass. It's already passed in the Senate, and it's waiting in committee in the House. And there are 8 states that have laws barring electronic prescribing now. So this is just one of those areas that makes you think, you know, you're going up the down escalator, or we're just, you know, we're putting fingers and gum in the dike, and the water flow is pretty strong. One of the other areas is in practice is opioids and driving. And I don't know how many of you actually are out there prescribing. Just out of a show of hands, how many in this room actually prescribe controlled substances? So the majority of you. So I would imagine at some point or another you wonder what's happening to your patients as they take those drugs and get behind the wheel. Do you hope that they're driving while you're not on the road? Anybody have that thought? Because it's a very prevalent thought, and this is an issue that's coming to the forefront. This is what Fishbane and Rosamos group in Miami said, that potential instructions to stop driving to a patient utilizing opioids essentially dooms the patient to a life of disability. And the answer to this controversy has widespread implications both for the patient and the medical practitioner. In their very well done systemic review, they found very little evidence to support impairment of patients who are on stable amounts of opioids. Now, this is an extremely controversial area because there's not one study that is absolutely definitive. And on the face of it, folks in the general public will think that if you give someone a drug that shlogs them, that makes them sedated, potentially may be euphorogenic and change judgment, that these are drugs that would be dangerous to have people drive with. So this flies in the face of what I would say is public opinion. There was a study that was done in Norway, which I think was one of the more convincing studies, just done last year, where they correlated a database of prescriptions dispensed, and it was an ideal place to do this because they have those records. They know what every person in the country is getting, and they have the data on all of the accidents. And what they found was that there were 13,000 accidents over a 1-year period with personal injuries, and that the risks of being involved in an MVA were increased in prescribed drug users over the first 7 days of their use. Now, many of us follow a practice of asking our patients not to drive for the first week or so after initiating drugs or escalating the dose. This is a very common practice that's been published by consensus in our literature. Now, in their study, what they found was that opioids were mildly elevated as a risk. And if you look at the risk of drugs like non-steroidal anti-inflammatories, the risks were rated as a 1.5. Opioids were 2. And they were not able to select out who of those folks were stable on their drugs and who were absolutely brand new users of these medications. Much higher levels of risk were found in drugs like benzodiazepines, and particularly the most sedating ones. Now, the CDC recently did a study looking at the blood of fatally injured drivers in West Virginia and found a higher prevalence of prescription drugs than illegal drugs in these folks. Almost 8% and 9% almost 8% of all those who died, and 9% of the drivers in these cases had greater than 2% of 5 drugs, including hydrocodone, oxycodone, methadone, Valium, or Xanax. So, you got to sit up and wonder. And it really raises a question that was raised just several days ago, maybe 30 days ago, in the New England Journal. This is an article I would call to your attention and suggest anybody who's interested read, by George Annis at Harvard, titled "Doctors, Drugs, and Driving: Toward Liability for Patient-Caused Accidents." And what he asks is, do physicians have any duty to patients who are taking drugs the physician has prescribed when those drugs are likely to have an adverse effect on the patient's ability to drive safely? Now, you might argue that we're not saying that they do have that effect, but when the courts look at this data, it's very easy for them to think the drugs that we're giving people potentially have a causative relationship. And what Annis goes on to do is tell the story of Dr. Roland Florio, who was a primary care physician, a PCP, for a 72-year-old patient. He treated this patient for over 3 years for asbestos, chronic bronchitis, emphysema, hypertension, and ultimately metastatic lung cancer. Saw the patient 6 times per year. Interestingly, following his lung cancer, the physician admonished the patient that while he was being treated with chemotherapy, he shouldn't drive, which I thought was very interesting. After chemotherapy, the patient resumed driving. And approximately 18 months after resuming driving, he lost consciousness and killed a 10-year-old boy. The current prescriptions that he had at that time were oxycodone, oxazepam or Cerax, metazolam, prednisone, Flomax, potassium, Paxil, and Lasix. The mother of the dead child sued the patient and the physician for neglect. The patient died before the case was heard, and the family settled with the patient's estate, and the case was solely brought against the physician. The court ruled that because the physician did not have a direct relationship with any of the third parties in this case, that the physician could not be held accountable or even related to the responsibility of this death. The family couldn't understand this, and they brought this to the Supreme Court of Massachusetts, which reversed the decision. So there was a summary judgment in this case to dismiss. The Supreme Court reversed the summary judgment. They didn't find the physician guilty. I want to be clear about that. They reversed the summary judgment, and they were quite split on this. It was a 4-3 decision. And I want to tell you what they said. They noted that the primary care doctor did not warn the patient of any potential side effects from the drugs that he had prescribed, and there was evidence of this in the record. And the plaintiff expert gave the opinion that the standard of care for a primary care physician includes warning elderly or chronically ill patients about the potential side effects of these drugs and their effect on a patient's ability to drive. So the justice in the majority wrote that this was clearly not a malpractice case because the physician did not have a professional relationship with the injured party. So the big question is, if this were to happen to us, would our malpractice insurance cover this? I would doubt it, but strange things happen. Because it wasn't malpractice, it was deemed to be ordinary negligence, and negligence required the plaintiff to prove that the defendant had a duty to warn, the duty was violated, and the violation produced harm. Duty was the focal issue, which, to my knowledge, has never been seen before in a court case focusing on a physician outside of their relationship with a patient that they're treating. And what the court did was they gave us examples of this. They said there's plenty of examples of liquor store owners being held liable for injuries to folks who have become intoxicated and gone out and injured others. And they talked about a cyclist who was struck by a car driven by a minor served by a liquor store. Bar owners held liable for motor vehicle accidents by patrons who drove after serving intoxicated patrons. They cited a forklift owner liable for leaving the keys in the ignition and drunk individual driving the forklift over a pedestrian's foot. The forklift owner was held liable in the case. And a homeowner liable for failure to store a gun that an adult son with a history of violence used to kill a police officer. So all of this together, the justice wrote, relying on these same principles, I conclude that a physician owes a duty of reasonable care to everyone foreseeably put at risk by his failure to warn of the side effects of his treatment of a patient. I found that the hairs on the back of my neck went up when I read that. Okay, everybody. Yeah. So there were 4 opinions in support. One of those, it was an interesting case. You rarely see this. The Supreme Court actually came out with 3 opinions. There were 3 in support, 1 in partial support that voted with the majority, and 2 against. So the one in partial support said, there seems to be no boundaries here. If we're going to support this, where I feel the physician is accountable, we need to put boundaries. And the other said, this is way too broad. All this is going to do is cause unrealistic expectations in society. And since we really can't give context to this, this is simply going to lead to unnecessary litigation. Bottom line is, this case has now gone back to the lower court, and this physician is being prosecuted now. So something to watch. What I suggest we learn from this is that we do have a duty to inform our patients that can be now transformed into a duty to warn. And actually, I think if you think about it, that duty to inform is really no different in this setting. We need to inform our patients that there are risks. That's part of the risk management plan, is information. You can't take a risk without sharing it with your patient. And part of that risk requires knowing what the foreseeable consequences might be. We've changed our practice because of this case. In my facility now, everybody gets a warning that not only can the drugs that we prescribe render them in a state where they shouldn't be driving, but over-the-counter drugs can do this, as well as simply fatigue. And really, the law prescribes that it's the individual's responsibility, not the physician's responsibility, but the individual's responsibility to monitor themselves and to mitigate any instability by not driving if they're not safe to do so. That's how you discharge your responsibility. It's interesting because, as Fishbane said early on in my slides, that you got to be careful because we're trying to improve quality of life. We're trying to increase function. Taking away the privilege of driving takes you the other way for most people. Takes you away from your primary goals, so you got to be careful about it. The one drug that we use, that we restrict driving on across the board, is a drug called ketamine. We're using it more and more, and the reason we restrict driving is that there's clear data that shows that unlike all the other controlled substances we use, ketamine affects judgment, and that change in judgment doesn't change over time. So until we have some clarity on it, and because we know that the government does not look at this drug clearly as a therapeutic agent, when they find it, it's PCP until proven otherwise. I feel this very greatly to protect my patients from a risk-benefit analysis. The functional loss is justified relative to the potential losses associated with that drug. Now, if that's not enough to make you feel kind of going up and down an escalator, consider medical marijuana. You guys live in a state that has legalized the medicinal use of marijuana. I did an NPR interview here yesterday, and it was a large part of what they were asking me about. And marijuana is very interesting. This is a map of the states that have legalized medical marijuana 4 or 5 years ago. It's interesting. They note that your law is largely symbolic. Okay, unlike other laws that seem to be stronger statutes. I've been accused of making this a political commentary by drawing the states red. I want to tell you that this is from Time magazine, not from me. I would have made the states blue. And you can add to this the state of Maryland. The Republican governor of Maryland recently heralded in a law legalizing medicinal marijuana, and the state of Rhode Island most recently legalized medical marijuana over a sitting governor's veto. When was the last time you saw a state bring a law over a sitting governor's veto? It doesn't happen very often. Then a little on maybe my phone, put it over here. And this is difficult because, again, I told you that I moved here from Boston. I moved to California 10 years ago from Boston. And I can tell you I never had a patient ever come to me in my clinic in Boston asking me for marijuana. And it was a few minutes into my new clinic that the first patient popped the question. and it hasn't stopped. I mean, the passion that Americans have for this is quite strong. Some feel that it's a pretext for other things, and others feel like it's truly a medical issue. There's no question from the scientific literature that we have an endogenous cannabinoid system, that cannabinoids are analgesic, they're appetite stimulants, and they're antiemetics. They're not better analgesics, antiemetics, appetite stimulants, and many other legal drugs that we have, but they do those things. You can't argue that. The data is very, very clear. With that, you could argue pretty strongly that smoking anything is a terrible drug delivery system. It has all sorts of potential harms. But irrespective of all that argument, the courts have been very clear about the medicinal use of marijuana. The first case that came to the Supreme Court, and this is actually the headline from it, no possible pain, the High Court says. I always wondered if that was a pun. But the court basically said that physicians cannot prescribe marijuana. Marijuana is in conflict with the Controlled Substances Act and it can't be prescribed, period. Nothing to talk about. However, in this ruling, they did say that physicians have a right to talk with their patients and endorse any therapy that they think is appropriate and potentially helpful for their patient. And I want to stress that because that's not just important about marijuana. That's important in general about what we do as clinicians. What defines our role as clinicians or the bounds of medicine is simply our intent to do good by our patient. That is where the line is. And I'm going to talk about some criminal prosecutions and things like that in a little while. And you need to remember this, that we're protected from criminal prosecution as long as we're practicing within the bounds of medicine, and that the bounds of medicine are set by our intent to solely help our patient, exclusive of our own needs. And the Supreme Court upheld that in this decision. Okay, you can't prescribe it, but again, that doesn't change what you can do with your patients. What you can prescribe is set forth by the Controlled Substances Act and by your state laws. What we're seeing now is really a change in marijuana in America. Your father's marijuana is not the same. It's now a lot stronger. And while these are averages, the potency increases that have now doubled on average have increased exponentially in certain places. And access is changing. This is actually a marijuana vending machine in Los Angeles, California. This is real. And there are laws out there. Actually, Barney Frank from Massachusetts is bringing a bill in the House that's trying to cool off some of the federal actions that are going on in some of these pro-marijuana states. So there's an enormous amount of tension here. Now, the Supreme Court actually heard the marijuana case a second time. And the second time was a case brought by two women from the East Bay in Northern California who were cancer patients asking the Supreme Court to protect their supply. That the feds were after them to take it away. It was legal in their state. They were using them medicinally, and they wanted the court to protect them. And they made a very, very clear, articulate, intelligent, and impassioned argument to the court about medical marijuana. And I must say that I think the court heard them very, very clearly and rejected their case based on accepting their argument, which is if marijuana is such a good drug, why isn't it a drug? Why don't we use it as a drug in America? And I think if you read what the Supreme Court said, it's very clear that they were looking at a breach of our drug system in America and a shunt that's occurred with marijuana that they want to stop. So they actually, and in that hearing, which was the last hearing of our old court, and that judgment said that patients do not have a legal right to use medical marijuana. Okay? We thought that the medical marijuana story was over at that point. until the next case that came to the Supreme Court, which was Justice Roberts' first case, our new Chief Justice. And it, in fact, was the Gonzalez versus Oregon case, the physician-assisted suicide case that the Supreme Court heard, which is very interesting because it actually impacts the marijuana decision. The physician-assisted suicide case could have really been about anything. It really came down to who sets the standard of care. You know, and many of us in pain medicine believe, as I do, that physician-assisted suicide isn't necessary if you bring good pain and symptom management to bear at the end of life. However, if you don't, people feel strongly that they want a choice. And the citizens of Oregon voted, I think, 3 times to uphold this law. The Attorney General of the United States was actually enjoined from any further action by the leading court in Oregon, and he brought this case to the Supreme Court, and the Supreme Court was conflicted because they had to come down on one side or the other of a conservative issue and leave one side of the conservative sector very unhappy. That is supporting states' rights versus supporting law enforcement. And they came down in support of the state. They said the state has the right to set standards of care, and the law was upheld. The key point here is that really what they said, way beyond physician-assisted suicide, is that the state sets the standard of care. The medical board is the arbiter of that setting. So, ragingly, we see a return of the medical marijuana action, the medical marijuana movement in America. So I would say the medical marijuana movement in America is alive and well, putting me in quite a quandary because I prescribe in a state with some of the strongest pro-marijuana, medical marijuana laws. And I don't know what to do when my patient comes to me and says, I'm using marijuana, it works, but I need something else. In fact, Dr. Junker and I last night had a long debate about what do you do with these folks and how do you handle it. And it's a tough one. I have to be very honest with my patients and say that I need to continue to be able to prescribe to all comers. And if I give someone an opioid who I know is using marijuana, I'm in conflict with the Controlled Substances Act, and I'm liable to have my DEA registration removed.
I'm sorry, how does that work? Why would that be the case? I mean, you didn't prescribe the marijuana.
No, I prescribe the opioid.
Right.
The law says, we got to read the Controlled Substances Act, and read your state law as well, and I'm sure your state law says this as well. If you know that somebody's using an abusable drug that's listed in the Controlled Substances Act, you're not allowed to prescribe controlled substances to them. Okay? You can't prescribe to addicts. That's what they're trying to get around, keep you from doing. Unfortunately, it has a lot more to do than that. But that's what the law tells us. So if you know somebody's actively abusing a drug, you can't prescribe. Now what I do is I talk to my patients and I let them know that unfortunately we're going to have to make a choice. You can use the drugs that I'm prescribing, or you can continue to use the drugs that you're using. And I'll be happy to prescribe everything else other than controlled substances. Yeah.
Addicts get sick. Addicts have pain. Isn't that a violation of equal protection against the law? If you're just losing one move.
I don't think so. Again, we're talking about active use. Okay, so a sick addict deserves treatment. If that's what you're saying, I'd say yes. But you can't say, look, and this is what Dr. Hurwitz said, who's the guy who I'll talk about it in a little while, the pain doctor in Virginia, who got 25 years in federal prison for drug trafficking. His argument was that he was giving known addicts drugs because he knew that if he didn't, they'd actually be abusing even more than they were. And he was actually protecting society. Well, it didn't fly. That doesn't fly. So again, in no way am I saying that you shouldn't treat addicts. And I'm not saying that people who use marijuana are addicts. Okay, I want to be really clear here. Okay, but the problem is that the law is very two-dimensional here. Okay, and you have to recognize that two-dimensionality of it to be able to work with it. Okay, and I don't know that I leave a lot of people hanging out there. I think within the boundaries of my system, they can work with it and I can work with them. But it's a problem. If I know that they're using marijuana, even though they say they're using it, the law says they're abusing it. And the law says that I cannot prescribe. My license is based on a rule that I can't prescribe if I know that someone is using anything on that list, okay, of which marijuana is there, okay? Until we take marijuana off, that's the way that it is. So, I think we have to just be really clear about it. I appreciate your comment. I hope that I've addressed it because it's a very, very important issue. And it really puts us in a box. I can tell you, I've taken marijuana off of my drug screen. Now, the DEA may come and say, why did you do that? And I would say the only things that I have on my tests are tests that give me useful information. Okay? I want useful information. Okay, I won't order an unnecessary CAT scan. I won't order an unnecessary lab test. Okay, so, and I've argued this with the administrator of the DEA. So again, these issues put us in a box. We're dealing with the issues of overprescribing. We're also dealing with issues of underprescribing. And there are a lot of consequences that doctors deal with on both sides of those extremes. So I'd like to look at these. And these really come from the medical board, the courts, and the legislatures. The medical boards are really the black boxes out there. I don't know how the Montana Medical Board works. I know that this book that I wrote, which is for the Federation of State Medical Boards, the Montana Medical Board has embraced. We really have had embracement of this book from every medical board in the country, and we're slowly rolling it out as we gather the funding to be able to do so. Montana was an early adopter, so I have to believe that you have a pretty good medical board. But in every state I go into, I hear horror stories from somebody who feels that someone was persecuted, because it's very hard to know what the rules are, who the people are. They're usually governor-appointed members of the medical board. They're usually not elected. You don't know what their policies are, and I can tell you that they're not even sure what their policies are, because times are really shifting for medical boards, and I'm going to give you a little bit of background on that. Now, I'm not going to go into terribly much detail here, but this was a case in Florida of a very good internist who treated all of the pain patients in her community, and the feds thought that was a problem. How come she's got all the pain patients? How come she's got the most controlled substances of anybody in her community? It turned out it was because nobody else would treat these people. She was actually quite good at doing it, and everybody sent their patients to her, and she was willing to treat them. She kept very good records. She used functional outcomes, and the medical board went after her solely on her pharmacy records. They used pharmacists to review the records. They didn't have a single specialist look at her case, and they removed her license and they fined her. She appealed. The appellate court upheld her. The medical board rejected the appellate court. She appealed again. The medical board rejected the appellate court again, continually fined her, and ultimately the 3rd District Court of Appeals, the highest court of appeals in Florida, admonished the medical board with this quote, and this is something you would never have seen 20 years ago. The board once again engaged in the uniformly rejected practice of overzealously supplanting a hearing officer's valid findings with its own opinion in a case founded on a woefully inadequate quantum of evidence. So this is what the courts are now starting to say to the medical boards, and the medical boards are hearing this. In 1999 was the first time a medical board actually sanctioned a physician for undertreating pain. This was Dr. Bildner. I think this was 6 cases, egregious cases in dying patients. I don't think anybody in this audience would disagree with the medical board's decision. And there have been 2 other cases, and I have to kind of jump away from the medical board arena and talk a little bit about the courts to give you the history behind this. You first had the Bildner case. The second case came to the medical board from a family whose father had died in pain in the East Bay. And they wanted the medical board to look into the case. The medical board reviewed the case, came back to the family and said, in fact, we support you, that your father was undertreated. We feel very badly about that. But there's nothing that we can do about it, because there's not a pattern of undertreating pain for this physician. And we only act on patterns of problems. So the family wrote the medical board what is now a famous letter asking what I think is a fairly profound question, and that is, how many times does someone have to undertreat pain for it to matter? That letter was also sent to a legislator who legislated a bill in California which turned out to be the first law requiring every physician in the state to get continuing medical education credit in pain and end-of-life care. So think about it. California has 1/6 of America's doctors, and they were all required to get 12 hours of CME in pain and end-of-life care in a 4-year period. And that was a big law. Hidden in that law was also a requirement, the first time in America, that the medical board had to publicly disclose its policies of how it judged physicians in cases relating to pain. And the Medical Board of California had to go back to the table and rework its policies and actually publicly disclose them, and I was part of that. And I can tell you that the policies that California has now are exactly the same as those articulated by the Federation in this book you'll be getting, and I'll go over those in just a few minutes. Now, the family wasn't satisfied, and the family sued the doctor. But in California, because of tort reform, you can't sue for pain and suffering after someone's died. So they got creative. They sued the physician for elder abuse. And none of us thought that this would work. There was one expert after the other that paraded through the court saying, in my community, this is exactly the care that the patient would have. This patient was cared for at the community standard. The plaintiff brought experts and evidence showing that there is a higher standard. There are national standards. There are professional standards that say care can be better and should be better, and that's what the jury focused on, and they convicted the physician. It was a $1.5 million verdict, and they were one juror away from punitive damages, which would have been exponentially more. So this was the Bergman case, which I told you about. There was a second case that came up about maybe 2 years ago, and that case settled on the steps of the court the day of trial with the physician, the hospital, and the nursing home. So we don't know the verdict. But in this case, the Medical Board of California did censure this physician. So now we've had 2 medical boards that have sanctioned physicians for undertreatment of pain. Most of us worry that they're going to come after us for overtreatment, that they're going to look at us as the candy man, that they're hiding in the bushes watching what's happening. And this is hard because it's very hard for them now to make that case. Medical boards now are I think, more worried about the undertreatment, and the sheer numbers of doctors who undertreat pain are probably much higher than the numbers of doctors who they could convict for overtreating pain. The overtreatment can be made, and it is being made in some places. So you will still hear a couple cases a year that are in the news where doctors are being hauled out of their practices, and we see this on 2020 Monday, 2020 Tuesday, 2020 Wednesday, 9/1, Dateline. I mean, this is widely in the media, and it's alarming when you see it. But basically, the standard of care up to now has been hard to understand. Medical boards now don't have any way to wriggle out. And the standard of care is really set by the Federation of State Medical Boards. Now, I shouldn't say that the standard of care is from the Federation, because what this is not a guide for us on how to practice. This is a guide on how medical boards should look at us, maybe even more valuable to us. And it's very important to understand what this says. My book is essentially an articulation of this, but I'm going to give you the cliff notes right here. The Federation of State Medical Board model policy on the use of controlled substances has some basic tenets, and they are that pain management is important and integral to the practice of medicine. The use of opioids may be necessary for pain relief, and use of opioids for other than a legitimate medical purpose poses a threat to the individual and society. Anybody outraged at any of this? None of this is too hard to accept. Physicians have a responsibility to minimize the potential for abuse and diversion. This is where my eyebrows start to go up. What does that mean? But we clearly do have a responsibility to minimize. I think we can all agree on that. That's what we are. We're risk managers in everything that we do. Physicians may deviate from the recommended treatment steps based on good cause, and this is not meant to constrain or dictate medical decision-making. So this is the heart of the policy. This is really what they say. This is what they tell the medical board to look for in your practice. That you're doing a complete patient evaluation. You have a written treatment plan. You're getting informed consent. You know, when I talk to doctors around the country, they get all wiggy about informed consent. How can I get informed consent? Who has time to get informed consent? Well, the bottom line, and I'm sure everybody here understands this, that the law assumes that anything you do to anybody is with informed consent. Okay? So it's up to you whether you want to document that you got it. If you document that you got it, you're in a much better position if you're challenged. It's very interesting that I doubt that any one of you here who does surgical procedures would ever do a surgical procedure on a patient without getting written informed consent, but you would do much more risky things outside of that arena without informed consent. Or all of us do. And that's because years ago, risk management told us that the only real trouble we're going to get into is with those procedures. But times have changed and we've not changed with them. I hope you understand that. We're required to get periodic review, which means follow your patients up. They don't actually dictate how often that should be. Be willing to refer when the patient's problem is out of your purview of expertise, and maintain complete and current medical records. Anybody have any problem with any of these? You know, the important thing here to recognize is that none of this is specific to opioids or controlled substances. This is the same requirement if you're prescribing antibiotics, you're giving a flu shot, you're giving antidepressants, etc. This is what is expected of you from good practice when you deliver care, period. The model policy says nothing about specific drugs, specific dosages, who to give them to, who not to give them to. Okay? It emphasizes these points. Now, these points deserve some extra emphasis, which is, how do you do a complete evaluation? What is complete? Well, within reason, and there's a lot of latitude for medical judgment. Simply write down what your plan is. I would suggest that informed consent requires education, and the whole informed consent process allows you to share risk. And that's really what this is all about, risk management. And that's what all of the regulators want to see from us in this arena, is that we're willing to understand that we're taking risk and we have a plan for it. Almost all of the cases where I've seen physicians effectively prosecuted did not do that. So when we talk about maintaining records, I'm not talking about making sure that you say exactly how long the needle was that you injected, or which room in your clinic the patient was in, and what part of the room that you sat in. The key here is that you're transparent about the risk that you're taking and your plan for managing it. That is what the regulators want to see. And that is what we don't see in these cases where doctors are vulnerable and really getting persecuted, in my opinion. If you do that, I think you've got enormous impunity, because we're all risk managers. Medicine is all about taking risk. If the best thing for the patient is not to take risk, that's what we do. We take risk on a risk-benefit analysis ratio, right? We weigh that, we document that, and then we take risk. And when we take the risk, we look for foreseeable adverse effects, and we try to mitigate them. If you put somebody on Tegretol, you're going to get a CBC once in a while, right? You'll probably get it at baseline, and you'll follow it over time. Doctors put patients on opioids all the time and don't look any further. Don't really think any further down the road. And the regulators want to see us doing the same kind of risk management that we do with NSAIDs. Who's going to put a patient on NSAIDs long term and not get a BUN and creatinine? But we don't think about the adverse effects of the opioids. We're not checking their testosterones, their vitamin Ds, their urine tox screens to make sure the drug that we're giving them is potentially in them, etc. And nobody's defined what appropriate vigilance and risk management is, and I don't think that anybody would have a question if yours is different than mine, as long as you have one. and it's consistent with your medical judgment. That is what medical boards are being told today is the standard of care. Okay? I'm going to shift to pain in the courts because if what I've told you to date isn't alarming enough, this will probably get you on the edge of your chair. I did tell you a little bit about the courts with the driving case, which is very, very new. That's actually something we're going to have to stay tuned to. We don't see a lot of malpractice cases in pain because to date there hasn't been a clearly articulated standard of care. Malpractice hinges on practice beneath the standard of care that produced harm. So there are very, very few of these cases, and I'm not even going to focus on them. The big problem we have are these criminal cases out there where doctors are being charged not as doctors, but as criminals, as drug dealers. I don't know if any of you have seen the wonderful article that Tina Rosenberg wrote. It was the cover story of the New York Times, I think at the end of June 2007. And it's on the web. I think she did a marvelous job. The title was "When is a Pain Doctor a Drug Pusher?" And she tells the story very, very clearly about the damned if you do, damned if you do position that we face. In my opinion, what I find is that there are very few cases of doctors who are prosecuted, and we have a new article that's just coming out in the Journal of Pain Medicine, led by the Center for Practical Bioethics, including members of the DEA on the authorial team, where we reviewed all of the cases around the country of medical board actions and court actions, and found that it's less than 1%. And the physicians who are most at risk aren't the specialists; it's actually the primary care docs. Most likely, in my opinion, because they're doing it with the least training and the least amount of time. This is data that's a bit of a squint in that you've got to really, really think about it carefully. If you're a very high prescriber, you may not be the average person that this study looked at, and you may be at higher risk. We don't know that yet. But what we find is if you look at all those doctors out there that are prosecuted, they break down into three groups. You have your good clinicians who are practicing at an extreme of the standard of care, but practicing within it, justifiably. I think there are very few of those. You have physicians who are very well-intentioned, but are practicing beneath the standard of care. I think we have most of the folks that are prosecuted in that group. And then you have clinicians practicing outside the bounds of medicine. As I told you, the bounds of medicine are defined by your intent to solely help your patient. So if you're running a pill mill to make money, you're just getting money and giving people prescriptions. Your intent is to make money, not to help your patient. And you don't really care if they get better or not, or if they sell the pills to someone else who it harms. If you're trading care for sex, etc. And that's, if you really look at the 60 or so cases a year where the DEA pulls a license, and it's very rare, it's down to about 60 a year from over 1 million licenses. They're all in that group, in that third group. They're all, really quite egregious, and I don't think any of us would disagree with that. The problem is, how many clinics did they torture by, coming in with flak jackets, or, simply taking the charts away for weeks, and then giving them back and saying there will be no action? We don't, unfortunately, really know those numbers. There's a very disturbing trend afoot, which is if a physician is an extreme practitioner, or even if a physician is beneath the standard of care, that line that separates us from civil to criminal prosecution is being blurred now. And what we're seeing is departments of justice in the state level and the federal level being increasingly willing to cross the line and prosecute criminal charges. And I'll tell you about two cases that I think are very, very interesting. One is the case of Frank Fisher, who is a Northern California practitioner. He's actually a Harvard Medical School graduate who never completed an internship or resident, opened up a general practice in very rural Northern California, and was well known to have a practice where people would line up in the morning from far away. Most of his patients were addicts. He had a cash business, and he ultimately said that when he was caught giving out drugs without doing physical exams. He said he couldn't do physical exams because there were really too many people in need, and he didn't have the time. And that's why he made that choice. They charged Frank with murder. There were 5 people who died. One of the patients that he was charged for their murder died in a motor vehicle accident in which they were the passenger. Think about that. And Frank wasn't driving and didn't hit them. It's interesting because to me, the Attorney General came to me to be their expert witness and revealed their case to me. And this just gives you a sense of how things get wiggy when you cross that criminal line. These guys are meat eaters, and they want a victory in court. They didn't just make the case that Frank Fisher was a bad doctor who was happy to make money giving away drugs. They actually made the case that Frank Fisher was a Unabomber. He was poisoning the citizens of California 1 tablet of OxyContin at a time. He was the largest prescriber in his county and possibly the largest prescriber in California at that time. And that was the case they made. They couldn't make it stick. They ultimately dropped it down to manslaughter. They lost that, and ultimately they dropped the case after 5 years of prosecuting Frank. And what's interesting is that they showed very clear evidence that Frank Fisher didn't do physical exams, was giving opioids to addicted patients who he knew were addicted, and when they couldn't make his case, the Medical Board of California gave him his license back. Frank is now back in practice. So what's wrong with this? Well, what's wrong with this is that, we put the accent on the wrong syllable here, right? The problem here wasn't that Frank was a criminal. The problem here was that Frank was challenged in doing pain management. He wanted to do pain management. He had never had a single educational session in how to do it. Frank Fisher now is actually a frequent speaker in national pain management meetings, talking about pain management. He's become a martyr out of all of this. And really, the organization that should have dealt with him was the medical board, and the medical board was actually ultimately precluded from doing so because of the way that the criminal prosecution went down. Now, consider the case of Bill Hurwitz, who we mentioned earlier. Bill was a practitioner in rural Washington, or in suburban Virginia, right outside of Washington, D.C. He had a very eccentric, extreme practice style that many of us in pain management would not support. He again had people lining up from many states early in the morning in his parking lot, many of whom were addicted. It was a cash business. Bill said that if he didn't make it a cash business, he couldn't be in business because no one else would pay him. When they arrested him, the media reported that he had made $1 million off of this business. It turned out he had over 8 years. So it's kind of interesting how you spin things, but Billy really had a very, very concerning practice, and he's the one who I said argued that the reason he gave known addicts opioid is because he thought that in the greater picture taken together, it was in their interest and society's interest to do so. He had lost his license 3 times and been given it back before he got arrested by the feds. And the 3rd time he lost his license while he didn't have his license, he became a lawyer. So he knew very well the law that he was breaking, and he did so anyway. He was really, in my opinion, a libertarian. He was found guilty on 50 of 62 counts and given 25 years in federal prison. His case was appealed, and while I got to tell you, I don't support his practice, and I don't think he should be allowed to practice, I don't think he was a criminal either. The problem with this case was, I don't think society was served by treating him as a criminal. All we need to do is take his medical license away, and we're all protected. The problem with this case is that the jury asked the judge 3 times, please explain the difference between a bad doctor and a drug dealer. Please explain that line between a doctor that is beneath the standard of care and a doctor who's no longer a doctor and now a criminal. And the judge refused to do so. And many of us, regardless of how we felt about Bill Hurwitz's practice, felt that that had to be addressed because it set up a precedent that would make any of us vulnerable. And we appealed the case. I helped write one of the amicus briefs for the American Academy of Pain Medicine, which I was president of at the time. And it went to the 4th Federal Court of Appeals, the Federal Court of Appeals with the lowest rate of appealing cases, and they appealed. They overturned the case based solely on that problem. He was retried, found guilty again, and found guilty on 14 counts, and given, I think, something like 5 years. And actually, I think he's going to be getting out in the next year or so. What was interesting on the way to the Hurwitz case was that the main expert for the prosecution was a former president of the American Pain Society who said some things that many of us didn't agree with. And I think it was 6 other presidents from the American Pain Society sent a letter to the judge repudiating the expert's testimony. Another interesting thing happened in that in the first week of the Hurwitz trial, the defense of the lawyers in defense of Hurwitz submitted something from the DEA called the FAQ. Does everybody know about the FAQ, the frequently asked question document? Anybody not know about it? So I'll tell you very briefly. This was a document that many of us in the field, and particularly June Dahl here, worked very hard to create with federal regulators, particularly the DEA, in answering common questions with simple answers around prescribing controlled substances. A few days, and this is something that was hailed to the press on the steps of the Washington Press Club, covered internationally and hailed as, balance between medicine and law. A few days after Hurwitz put this into evidence, the DEA said that the FAQ had errors and in fact never existed. And it never existed because it hadn't been properly vetted through the Federal Register, and they would tell us more about this later. So please stay tuned. This happened, I think, in August. They sent out an interim report in November. There was another clarification of the clarification in August, a final policy statement in September, which resulted in a final policy statement in actually December of 2006. And I just want to give you a sense of what this all related to. So basically, the problems with the FAQ had to do with tenets around refills and overstating our ability to prescribe to suspicious people and our requirements to prevent abuse. So this is what they said in the final policy statement, that dispensing controlled substances for the treatment of pain, the registrant has responsibility to prevent diversion and abuse, properly determine the legitimate medical purpose, and act in the usual course of professional practice. A physician prescribing controlled substances has an obligation to take reasonable measures to prevent diversion. It's interesting that in this document, different from all the other clarifications where they use the word minimize, here they use the word prevent. But they do state it's reasonable measures to prevent. So I don't know how to prevent diversion. I don't know if you know how to prevent diversion. This is a tricky thing, and I think even the DEA is rethinking this. Others have clearly said that we have a responsibility to limit the risk and the impact of the risks that we take. What they said was that a ruling that a practice of writing multiple prescriptions at a time with do not fill until next week, a month from now, 2 months from now, the do not fill until practice was tantamount to a refill, and we couldn't do it anymore. Even though they had publicly supported it in the past, now they were saying they've reinterpreted that, and that's in conflict with the Controlled Substances Act, and we can't do it. This was something that we all were up in arms about, because the do not fill until practice actually makes prescribing safer. It allows you to control the amount of meds that a patient gets at any time. Does everybody understand what I'm talking about here? So you could write a prescription with today's date to say fill 10 pills today, 10 days from now, with the same date as today on the prescription, but in 10 days get another 10 pills, etc. You could wean somebody safely that way. Well, they did away with that. We got very upset about that. And we actually met with the DEA, and we brought in representatives of a couple of major national, international pharmacy organizations who had data that showed that without that provision, actually abuse went up. In the time that physicians were not allowed to use it, abuse went up because patients were getting larger and larger amounts of drugs at any given time. The DEA reversed themselves, and they have since allowed that. So as of December last year, you're now allowed to do that again, and that is in the Federal Register. So I hope everybody understands that. I'm happy to clarify that in the Q&A. If any of you are really interested in this topic and want a very simple explanation of what's happening with prescription drug abuse and how the drugs are in the White House, and really the national policy looks at it, just look up the President's National Drug Control Strategy. It's on the web. You can look at it every year. I want to go through a few of the things that they've said, because to me they're very, very interesting. One of them is, this is what the drug czar said in his 2004 press release. Physicians must perform risk assessments on patients at risk for potential abuse. This is particularly true for patients entering opiate therapy for chronic pain. We're now closing this gap in part through the development of something most Americans assume already exists: state-level prescription monitoring programs. PMPs, as they are known, are designed to facilitate the collection, analysis, and reporting of information on the prescribing, dispensing, and use of pharmaceuticals. The effectiveness of PMPs can be seen in a simple statistic. In 2000, the 5 states with the lowest number of OxyContin prescriptions per capita all had PMPs. According to the DEA, the 5 states with the highest number of prescriptions per capita all lacked them. It makes perfect sense, right?
Statistically sound.
Yeah. It's really good that these guys are leading our war on drugs. I met with the drug czar, and we had a long talk about this data. And the flaw here is this, that laws are not out there to prevent the appropriate use of these drugs. And they don't know which of these drugs were appropriate and which weren't. We know that in appropriate hands, these drugs are underused, not overused. So how can you argue that the states with the lowest amount of drugs are the ones that are best served? And I gave them a very clear example. When I came to California, we had something called triplicate prescriptions. They were 3-part prescriptions. You could only get them from the Department of Justice. You could only get 100 at a time. And you had to use them for Schedule II drugs. You couldn't write Schedule II drugs without this form. You kept 1 copy, 2 copies went to the patient. The patient gave the 2 copies to the pharmacy. 1 copy stayed with the pharmacy. The other copy went to Sacramento, to a big warehouse. Guess how those were organized? By the date they came in. So they could not find my triplicates if they wanted to. This was a big, giant scare tactic. Okay? And it worked. Less than half of California doctors had them, and those who had them were afraid to use them. And we couldn't get rid of them because every year law enforcement would go before the legislature and say, if you get rid of triplicates in our state, we will go from one of those low prescribing states to an abuse state. That's the words they use, an abuse state. Until we were able to go to them and show them the data that in fact they're right, that in California we had a very low Schedule II prescribing rate. We had the country's worst Vicodin problem. And what was happening in California was a substitution effect, that doctors didn't even get these prescriptions, and they would tell their patients, boy, if only I had those prescriptions, I could write something else, but you'll have to use 20 Vicodin a day. And not a week would go by that I wouldn't see a patient in my clinic who wasn't Tylenol toxic. So this was a huge problem. Do you know what drug is the most commonly abused opioid in America? Hydrocodone. And you probably also know hydrocodone is the most prescribed drug in America. Why is that? Why is that on either level? It makes no sense. It makes no medical sense. It probably makes sense in terms of the ways that our laws guide us and the ways that our social values guide us. And it was very clearly seen in California. We got rid of triplicates because of that, and now we have a system where you need to have security paper pads to write any controlled substance regardless of schedule. But we also have another prescription monitoring program, which is an electronic prescription monitoring program, which we've had for years, and we're actually now analyzing. It was interesting because at the time of Katrina, President Bush signed into law a prescription monitoring law called NASPR. Very few people know about it because Katrina was going on, but this was a bill that was actually brought to help states develop their PMPs. Interestingly, it's never been funded. Since 2005, it's never been appropriated. But this was a bill that I actually worked on, and the American Pain Foundation and others worked on. And we opposed at a certain level. Not because we don't support prescription monitoring programs. I do support prescription monitoring programs. I think prescription monitoring programs are not only important, but they're the future. And if you don't like them, you better learn how to live with them, because we're all going to have them. But what we argued was that there are good PMPs and there are bad PMPs. The California PMP that I adopted when I moved there was clearly a bad prescription monitoring program. It was one of the country's oldest. It was a paper-based program with triplicates, and it actually undermined prescribing. In California, we went from a state that had a very low monitored problem to a state that had an egregious unmonitored problem. How did that help society? So we argued that this NASPR bill needed to tell states what is a good PMP. A good PMP is a clinician's tool, not a clinician mousetrap. A good PMP gives clinicians information that helps them to make good decisions. So it gives you data at the point of care that will positively influence your decisions for your patient's best interest. So there are states like Nevada and Kentucky that have electronic PMPs where a physician can sit down at the time that they're treating their patient and see where they're getting their drugs, see what drugs they're getting, and make a decision so that doctor shopping is substantially reduced and doctors' fear is substantially reduced. So patients who don't have a problem get a pass. And not everyone is looked at as a diverter until proven otherwise. Unfortunately, with NASPR, we could not get NASPR, the Republican authors of NASPR, to mandate that the data would be available to clinicians, even though the data was mandated to be available to law enforcement. And we couldn't get them to mandate that the programs would be housed in agencies invested in public health rather than law enforcement. And those were the two issues that we had. I think since this has passed, the Department of Health and Human Services has understood this. And I think if this ever comes around again, I think we will see those tenets embraced. We now have a number of new legislative initiatives afoot. I'm very, very pleased to tell you that we have 3 major bills in Congress right now. two of which look like they're on their way to passage at any moment. One is a bill that will reinforce pain services for our military, a bill that will also reinforce pain services for our veterans through the Veterans Administration. Both of those bills are now appearing to be unopposed and on their way to passage. And it appears the president would sign those. We have a third bill, which is the National Pain Care Policy Act of 2008. It's been brought by Orrin Hatch and Chris Dodd in the Senate. It's been brought by Mike Rogers from Michigan and Lois Capps from California in the House. And we're struggling to get priority. It's a bill that doesn't have a lot of opposition. It has a little bit. Because there's still a belief in Congress that anything that helps patients in pain will produce greater addiction and drug abuse in America. And this is a notion that we're trying to disabuse. We've actually sent the responsible opioid prescribing book to every member of Congress. We're not sure if they're going to read it, but at least they're going to. I think we're making headway. Another interesting thing that's happened in the regulatory arena is what's been happening in your neighbor state of Washington. Do you consider Washington a neighbor? Yeah. Do you border on Washington? No, just through Idaho, right? Yeah, but it's pretty close. Washington has a very interesting new guideline. Have you heard about this? The Washington guideline is very interesting in that, I think that very well-intentioned people looked at a problem that they have with rising deaths related to methadone. And said, we've got to do something about this. We would argue the first thing to do is to figure out whether there really is cause and effect, but they didn't think that that was important. So they went straight to a solution. And the whole thing is based on questionable data and data analysis. But basically, they think there's a problem with patients getting high doses of opioids, and they came up with a guideline. They brought together a consensus group, and this guy named Gary Franklin, who runs the Medicaid and the Workman's Comp group there, pushed through a guideline that says that they recommend that if you have a patient on more than 120 milligram equivalents of morphine, you should get that patient a pain specialty consultation. Which, I don't know, can you argue with that? I think everybody should have a consultation. I think everyone has some pain every now and then. You should all have a specialist. I think every diabetic should have an endocrinologist. I think everybody with an infection should have an infectious disease doctor to look at them. I think that in a world where we have no limits to resources, that would be great. I think everyone should have a full body MRI every year. But unfortunately, we don't have many pain specialists. And even if we did, here's the kicker. We don't know what they are. Let me say that again. We don't know what a pain specialist is. What's a pain specialist? If I send somebody in my community who's on a gazillion milligrams of opioids to a pain specialist in my community, that pain specialist may be no more prepared to deal with their opioids than the general practitioner who sent them. That's the problem here. And that's the misguidance here with this logic, that there really is this solution out there. And again, I don't question their sincerity in trying to deal with the problem, but the problem is that what they do is they wind up undermining themselves. And they send some very perturbing messages to me, which is, number one, don't worry about being vigilant until you get to high doses. And when you get there, don't believe that you're competent, get someone else. Well, that's not the way we have to do it. The way we have to do it is we've got to get everybody competent to use these meds because pain is widespread. There are lots of different statistics out there. We don't have the perfect statistic, but we know that roughly half of America is in pain at any given time, and something in the range of 50 to 100 plus million people have chronic pain at any given time. So there aren't enough specialists. There'll never be enough specialists. Primary care has to come to the table here just like they did with diabetes. This is a public health crisis. We don't train our doctors on what pain is, how to treat pain. I congratulate you all for coming to this symposium and learning more about pain. This is unfortunately what we're going to have to do, and we're going to have to change how we change our medical students, or how we train our medical students. But in the meantime, if you put barriers in front of doctors to prescribe, just like in California with the triplicates, you're going to wind up with exactly the same thing. You're going to see a diversion in medicine. That's what we had in California, diversion. We diverted Schedule 2s to Schedule 3s. And in Washington State, you're going to see that doctors are going to be much less willing to prescribe and much less willing to prescribe appropriately, and they're going to be off the hook for actually getting the education that they need. Who are going to be the losers? The patients. And there's no data that those patients are the ones that are ramping up the street levels that are causing the problem. So what we may have is a solution that doesn't help the problem of abuse and harms legitimate patients who appropriately are treated. So, this is the problem that we have with policy out there. It's being, widely looked at in Washington and kicked around, and I hope that common sense will prevail there. We're seeing changes all over the country. The federation's involved in every state changing policy with medical boards, and I think we're seeing more traction now than we ever have. And meeting in the national meetings with these medical boards, they want to be educated because they're the ones who are being held up, and they're the ones in the media when doctors the bad doctors, are found to be beyond the bounds of medicine, and then they question why wasn't anybody out there watching. So the bottom line here, and I'm going to end here with these comments, is that essentially risk management is required. How do we do our risk management? Well, nobody knows. That's the bottom line. I can't stand here and tell you that you have to do it my way or somebody else's way. You just have to do it and show that you're doing it. That's really all that the regulators are looking for. But I want to go over one very, very important and I think simple but profound issue, and that is that pain itself is an untestable hypothesis. You can't prove that anyone does or doesn't have it. Not a week that goes by that I don't hear somebody say that this patient doesn't have pain or this patient definitely doesn't have pain relief or something like that. And it says more about us than them. You can't rely on pain relief as your primary outcome. You need something else. I'm not saying that it can't be a good outcome and an important outcome, but you need something else, and that something else tends to be quality of life, which is typically measured by function. Whenever I put someone on an analgesic, I ask them a very simple question. That is, what do you want to do with this treatment that you can't do now? And I look at the answer across the full domain of life. I look at social, psychological, spiritual, medical variables, and I make simple lists, and I follow those lists as I see those patients over time. It's as simple as that. And it's really based on the fact that the one outcome that the regulators are most concerned about, that being abuse and addiction, is intimately connected with dysfunction, the opposite of what I'm looking for. The definition of drug addiction really hinges on the compulsive use of a drug that causes dysfunction and the continued use despite that dysfunction. Okay? If your outcome is a functional gain, you're diametrically opposite to that other outcome that you're trying to avoid. And even if it occurs, just like a patient who you've given an NSAID and you bumped their creatinine, you're on board. And no one can hold you accountable, particularly if you've gotten informed consent with the risks and done standard practice. So my advice to you is if you're going to work with controlled substances, you've got to have a risk management approach and you've got to incorporate function there. I would suggest that you take a universal approach to your patients because we've learned that we can't tell who's abusing. Don't just screen the addicts or the chronic pain patients or the people with tattoos or the pierced ones. It actually forces you in disparate care, which is exclusionary and really probably unethical. A universal approach makes a better sense across the board. Understand that when you're going to get duped. We all get duped. And if you never get duped, you're probably practicing a very restrictive brand of medicine. And understand that if you're practicing with your eyes open, you're going to see some patients who don't get better. They maybe have a problem with addiction. The data would suggest that somewhere around 10% of your patients will. Or they may not get better for a lot of other reasons, and you really have to be circumspect. The reasons are beyond the scope of my talk here, but I'm happy to talk about those in the Q&A. But you've got to keep your eyes open and have some kind of plan for your patients, understanding that patients that abuse drugs and patients who are addicted to drugs typically do not subscribe to functional restoration plans. They don't go to the support groups, they don't go to the gyms, they don't go back to work. I ask my patients to show me proof that they're exercising. How many patients with chronic disease don't need to exercise? 0. And they can prove that. It's not hard. How many patients don't need psychosocial support? And with the very common sense gains that you can list on a napkin, those patients can also be charged with the task of bringing evidence. So that's the other topic that I talk with them. How are you going to be able to show me that you can do this? They bring their family members, etc. And addicts can't do that. And drug abusers, entrepreneurs who are small businessmen who are selling the drug on the street, they're not going to buy into that plan either. So again, come up with what's reasonable for you. Use your best medical judgment. Risk management is certain. What it entails is not clear. Err on the side of being compassionate. Stay within the bounds of medicine. Do what you think is right for your patients. Make it clear that that's what you're doing, which means document transparently. Say, there's a risk of doing nothing here. If I don't treat, this is what I think will happen. If I do treat, this may happen, and this is my plan in case it does. That's all you need. It really can be as much as a 2-sentence dictation that keeps you safe. Understand what the Federation wants of you, and I hope I've not frightened too many of you this morning, and I very much appreciate your attention. Thank you.
I want to ask your all permission to maybe skip the break, because it's pretty well fed at this point. But there is a break table out there, and there are granola bars and more coffee. And we're only going to have Scott Cushman here for a very short period of time. He doesn't get to stay for the Q&A after the panel because his plane is leaving. And he talked through the whole question and answer session, so, which we told him he could do. But so just take breaks as you want to, but now we have a half an hour that we can ask him questions until the panel stops.
In my defense, I want to tell you that I thought I was perfectly on time because my watch is an hour earlier. I had no idea that I went on that long. I'm not shocked, but... Yes, sir.
First of all, I want to really thank you very much. It's a very educational talk. I appreciate all the work that you want to do. I made a long list of comments, so I'll try to keep it short as well. One thing I brought with me from my practice from Oregon, which was really helpful for me in Montana. In Oregon, when you prescribe these medications chronically, there's a state statute that you have to give the patient an informed consent. And that informed consent to treatment of opiates goes through things like addiction and driving and sedation and side effects. And I brought that with me here to this practice. And I use that. So when I enter a pain contract with my patients, the first 2 pages are the agreement to treatment. And then the second 3 pages are all the things that how we manage opiates. It's a very nice document. And if anybody wants that, you can contact me and I'll give that a copy of that. That document's been reviewed by Dr. Mulgrew. And my email address is tmulgrew@stpete's.org. And I've got it in an email format, and it's been reviewed by our legal department, so it's fairly important. Another thing I want to mention is also in Oregon, we did have a medical marijuana law, and there's a couple of things that I do here in Montana that help me manage patients that come with marijuana. I use several criteria to take them on as patients. And my first criteria is that they need to be compliant with and have then failed standard medical treatment. They don't come to my practice for marijuana only, and I'm pretty strict on that. Another one that I do is I give them a trial of Marinol, which is a Schedule III drug, which is THC, which they don't have to smoke. So patients will complain that they can't afford the medication, and I don't believe as a physician that they can obtain marijuana on the street for cheaper than Marinol. And then the number 3 thing that I do is I require them to document vocational rehabilitation, return to work, return to school. I will not prescribe marijuana for people that are unemployed or completely disabled.
I just need to stop you, and I think that the folks want to probably ask some questions, so we should limit this a little bit. I just want to be clear, you can't prescribe marijuana. As you said, you don't prescribe it for this or that. You can't prescribe marijuana.
Well, I wanted to ask you though, with the medical marijuana policy that I have, the fourth thing I do is I don't prescribe it, they obtain it on their own.
Correct.
So what's your opinion coming from California on medical marijuana? Is that a reasonable set of things that I'll lead in my practice?
So, as I said, there's no question from the literature that marijuana is analgesic, it's an antiemetic, it's a appetite stimulant. It's not a better one than other ones that we have out there. So it's a real judgment call. I just find smoking marijuana is not a route of administration that I can endorse, and I would say the large majority of patients who use it want to smoke it. So there are other ways to get the same effect. We just concluded a fairly large study of smoked marijuana on neuropathic pain, and it's interesting, our results show that we found a dose that was analgesic without producing cognitive effects, and it was the first time that dose relationship's been seen. But irrespective of that, the negative impact on health from smoking, just from the toxic effects of the smoke, would preclude that. I don't find my patients like Marinol. They don't use it. They don't feel that it's in any way the equivalent. So really, marijuana right now is not a treatment option. I'm waiting for Sativex, which is a sublingual THC product that's legal in Canada, and I think that will have a role. But until that's here, marijuana is not a big treatment option for me. Now, if the patient's using it and they're using it effectively, and I don't lose my DEA license by knowing that, I'm happy to endorse that for them. Yes, sir.
This is almost ancient history, but I wonder if you may have any follow-up on what became of the physicians who were treating Elvis Presley or Marilyn Monroe at the time of their deaths?
I honestly don't know. Good question. Yes, ma'am.
You were speaking of driving, and I'm thinking also of perhaps other unsafe things that we might do as patients. And I'm wondering if there are ways that that we could measure medically the dangers of opiates or opiates plus other drugs at any point in the cycle of our treatment, either currently or to come, perhaps.
Well, thank you. I think that's a very insightful question. I think there's going to come a time when we don't put patients just on drugs and send them out there to use their judgment, but we actually do tests for them. There are all sorts of simulator models and things of that sort that are probably going to be fairly easy to do in an office in the future, and there are many groups working on those. But in the meantime, we don't have them. And what your question is reminding me of is a point I want to make, which is I'm much more concerned about sending my patients out with Neurontin and driving than I am with them being on morphine or another opioid. These drugs, make patients clouded. They don't get tolerant to it. I think it does affect their psychomotor skills. It's never been looked at, never been studied. And again, I think we have patients on a lot of things, let alone over-the-counter things that they're taking and driving that haven't really been considered. And I think that this one case in Massachusetts is really opening the box now. And we're going to see a lot of national attention on this. In the meantime, I think it's got to be very clear to everybody that you do have a duty here, that that is probably taken care of within your informed consent process, but you got to do that process. And it doesn't just relate to opioids. It relates to any drugs that potentially might be sedating, etc. It is possible to send people for testing. You know, every DMV, every Department of Motor Vehicles, the Registry of Motor Vehicles in the country has the means to test people. The problem is, once you engage that, you're putting your patient at risk for losing their liberty to drive. So it's something I don't do lightly, but it would be nice if you could have something within the confidence and the HIPAA protections of the care that we provide. It's not there quite yet. Yes, sir.
I wonder if you could speak more specifically about how you measure function, quality of life, and if there's certain standard formats that you do that with, and what advantages you find in what you've tried.
So there are a host of scales and ways to do it, and I don't use any of them. They're laborious to use. If you set up for it and you have a scanned program, you can do it very quickly. And I do believe in the future we're going to kind of be in a kiosk type model where the patient will come in and all that stuff will be done on a computer for us, and all that data will be given to you. But right now it's at the point of care, and using scales is too laborious. It's really quite simple. I mean, again, what I do is I find out what is it that you couldn't do without the drug that you're doing now or you're not doing now. What is it that's going to improve your quality of life? And on top of that, adding the dysfunction scale. How much dysfunction is in your life? And asking, maybe my treatment's causing that. Not that I'm making the patient addicted, maybe I am, but I may be making them so schlogged that they can't function. The patient that comes to you and, says, my pain's a 1 out of 10, it was a 10 out of 10, and these medicines are great. Is that treatment success? I don't really care what the VAS score says at that point. We got a problem. And why would anybody want to live their lives that way? And you start asking those questions. It's a very common sense approach in my opinion. However, it is possible to do this quite quantitatively if you wish, and there are numerous scales out there to do it with. Yes, sir.
Do you know if film pertains to all levels of clinicians that can write opiates?
I believe it does.
Hi, as a psychiatrist, I never prescribe opiates, but I do find myself prescribing benzodiazepines from time to time. And I was particularly alarmed about my intention that the DEA sets out a guideline that sounds pretty vague to me when they say that we need to use reasonable measures to prevent diversion. And what I'm uncertain about that is what that means, and if we could get some more specifics.
I agree. I'm clear about that. I'd like more specifics too. I don't think they're going to give them to you because I think they're really looking at the gross abusers, and they're throwing language out there that they're not really thinking about. I mean, they recognize that this is an imperfect science. They're not looking for you to catch everybody. They're actually just saying, we want you to do what you can do. They're not saying what that is. So if what you can do is a drug screen, is a functional assessment, is asking your patients, are you better, are you worse? And maybe limiting how much you give, making sure that family members are coming in, watching for the understanding what the signs of addiction are, which I'm sure as a psychiatrist you understand. I think those are reasonable. The problem is that what we face is a blurry jury.
Right.
And we don't know.
Open to arbitrary decisions.
It is arbitrary, but I got to tell you, it's not just arbitrary here. This is widespread. When medical boards look at doctors, it's all blurry. There are no real hard, facts. There's very little of what we do. I'll tell you, as a psychiatrist as well, your field is one of the blurriest in terms of the standards. There are very few standards that you could judge. So in any case, I can get two opposing doctors that say that the standard of care is completely contradictory to the other. So that's the world we live in, unfortunately. I don't think you should be alarmed because I think that vagueness protects you. The vagueness is there because really all of this is based on medical judgment. And that's what's protected in all of this. As a practitioner, if you're using sound medical judgment, you're using reason. That even if you believe that Hurwitz really believed that it was in the patient's best interest to give them the opioid, he would not be a criminal. The court didn't believe that he believed that. Okay? So if you're not out at that extreme, I just don't think anybody would ever go after you. And in someone who watches these cases nationally, you just don't see it. So I wouldn't get alarmed about that. In fact, I feel quite protected by that because no one will come and say, because, practice A is doing it this way and I'm not doing it that way, that I'm not doing it right. Okay, so that's all I can say. I don't think the DEA is going to answer, but the DEA will be here later, or they may be here now. We can ask them. Yes, sir.
Yeah, what do you do if you have a patient that rumor has it that they're diverting?
Yeah.
Can you fire them? And if you do, can you tell them why? I mean, there must be some legal ramifications and they're going to deny it.
So I had a patient in whom I learned that from the pharmacist that an anonymous source said the patient was diverting their drugs. What do you do with that?
You fire them and you don't tell them why.
You fire them?
Yeah.
Why do you fire them?
Well, you hear it from reliable sources, a number of sources.
So I got a pharmacist told me that a anonymous source said the patient was diverting drugs.
I wouldn't do that.
Yeah, I wouldn't do that either. I think you got to be careful. And I think we have to be very careful because you have, you're in a couple of different boxes here. One is you're in a HIPAA box. You got to be careful about your information that you share. On the other hand, when someone tells you that someone's diverting drugs, that's not information that their health is at risk. That's information that they're committing a crime. I believe it's a felony. So now you've been told about a crime. So I honestly, I think we should ask some of the people who are in law enforcement who will be with us today. I'm not going to tell you exactly what to do because that's not my purview of expertise, but I'm very, very, very cautious to leave my position of confidentiality with my patient unless I have clear evidence and convincing evidence that a crime has occurred and that I have a responsibility to do so. My first responsibility is always that confidential relationship. Now with that, within that relationship, you have to ask yourself, if you find out that someone's diverting, you got to act on it. But is kicking the patient out of your practice an action that's warranted? Why kick them out of your practice? Is all you do for patients in pain give them controlled substances? Is controlled substances your only analgesic? It's not in my practice, so I don't fire these people. I offer them whatever else I can to treat them. They often don't want it, or sometimes don't want it, and it's a choice that they will leave, or they're so shamed and humiliated, no matter how we try to avoid that, that they leave. But again, I would rarely fire a patient. I fire patients when they are violent, they injure staff, and they can't modulate they can't modulate themselves in a way that's compatible with being able to give them care. Short of that, I treat them, but I respond very, very seriously to crimes and to diversion. Yes.
I just want you to tell you that we have 4 minutes.
Okay. That's fast. Do you review medical records, or do you just start fresh with every patient you have, do metabolic panels that check their functions?
I review everything I can get.
Okay. I had a patient last week in an urgent care setting that could barely hold her head up, and she's a diabetic. She's roughly 50 years old, and she had been put on methadone the week before, and told to advance the dose in a week's time to 2 pills twice a day. And was, kind of stumbling drunk and fell and injured her arm. And it was prescribed by a pain person in Missoula, I can't recall whom. And she was blood pressure about 67 over 40 something. And her creatinine was like 4.5. So I just want to remind everybody that if you can get records, look closely. If you can't get them, you better start all over and double check that kind of thing.
Yeah, It sounds
even
like
though it's very difficult to do.
Sounds like it was pretty obvious that there was a problem there. Methadone's a tricky drug. I think, I probably don't have to go into that, but if you don't have good renal function, you're probably, simply by having a low renal function, you're probably increasing your circulation by 40%, and there are all sorts of drug interactions.
Right, she's on 10, 12 minutes.
Okay, I think this has to be the last question.
Just a really quick one. HIPAA always kind of blurs the lines of what can you do, what can't you do. And I recently read an article that if you know a patient is impaired and they are leaving your office, you you are pretty much obligated to offer to help them find a way to leave with a different ride, and if not, offer to call a taxi and document all of that, because then if they go out and someone gets hurt, that you are liable, or could be held liable due to a recent incident. But is there an issue if you call the police with HIPAA compliance at all, and can you tell them to put the HIPAA on that? And where's like communicating with pharmacies and stuff, all of that?
So you're absolutely right, that you have a responsibility if someone's, in your care, just like the parent of someone who, a parent and someone who got drunk in your house, at a party, or someone got intoxicated, not to let them drive drunk. So you can't let somebody go out. You've got to protect society in that respect. Now the question is where the line is that you could break their confidentiality. I honestly don't know the answer to that. I think it's a very, very good question. It may be state dependent, but at some point safety trumps confidentiality, and you need to make a decision. And I would never feel that if you really felt that the patient was unsafe and the patient was at risk to others as well, that I'd err on the side of breaking confidentiality. You don't have to break a lot of confidentiality to keep that person safe. So again, it's a gradual rule. If you don't have to break a lot to provide a lot of safety, you do it. If you have to expose somebody for very little gain, you don't do it, and you weigh and measure that way. Thank you so much. I'm sorry I took up so much time.